So today we will discuss the different ways obligation can be legally extinguished under Chapter 4 Extinguishment of Obligation. Specifically, we will cover Section 3 Condonation of Remission of Debt, Section 4 Confusion or Marriage of Right, Section 5 Compensation, and lastly Section 6 Novation. This principle play an important role in resolving financial and legal obligation efficiently. Condition or remission of debt. Article 1270 Civil Code. So, condition or remission is when a creditor voluntarily forgives a debt either fully or partially without receiving anything in return. It is essentially a gift and must be accepted by the debtor. It can be done expressly through a formal agreement or impliedly based on action. So, there are 6 requisite of condition, what we call. So, first is the gratuitous. So, the creditor does not receive anything in return. Second is accepted by the debtor. So, the debtor must agree to the forgiveness of the debt. Third is demandable obligation. So, the debt must be legally enforceable. Fourth is capacity of the parties. So, both creditor and debtor must be legally capable of entering into contracts. Fifth is must follow forms of donation. So, if expressed, it must follow legal donation requirements. And lastly, not inofficious. So it must not violate laws on the nation or leaving the creditor without means to support themselves.
So there are 3 kinds of condonation. First is as to form. Under the as to form, there are 2. First is expressed. Expressed is done formally following legal requirements for donation. For example, X owes Y 100,000 pesos. Y sent a notarized letter stating that he forgives the entire debt. Since it is written and followed the donation rules, the debt is legally extinguished. And second is implied. Implied can be inferred from the creditor's actions, returning a promissory note without payment. So, for example, X owes Y 50,000 pesos. Y voluntarily gives the promissory notes back to X without asking for payment. The law presumes that the debt is condoned unless proven otherwise. So the second kinds of condonation is as to extent. So under the as to extent, there are also 2. So first is total. Total is the entire debt is forgiven. So for example, a landlord completely forgives the unpaid rent of a struggling tenant. The tenant no longer has any obligation. Second is partial. So partial is only a portion of the debt is forgiven. So for example, a bank reduced a loan penalty from 50,000 to 10,000 pesos, but still requires payment of the principal. Only the penalty is condoned, but the principal loan must still be paid. The last kinds of condonation is as to constitution. Under the as to constitution, there are also 2. First is inter vivos. Inter vivos takes effect during the creditor's lifetime. So for example, a father forgives his son's loan while he is still alive. Second is mortis causa. Mortis causa takes effect after the creditor's death or like a will. So for example, a businessman states he is will that all debt owed to him are cancelled upon his death. So the condonation takes effect after his passing.
So there are 3 articles under the legal presumption related to condition. So first is Article 1271. So if a creditor voluntarily hands over a debt document to the debtor, it is presumed that the debt is forgiven. For example, X borrowed money from Y. Later, Y hands X the original loan agreement without asking for payment. So the law presumes that the debt is condoned. Second is Article 1272. So if a debtor is found with the original debt document, it is presumed that the creditor voluntarily gave it to him, indicating remission. For example, a borrower finds the original promissory note in his possession without returning the money. Unless proven otherwise, the debt is presumed to be condoned. And lastly, Article 1273. If the main debt is condoned, any interest or penalties are also removed. However, if only the interest is condoned, the principal must still be paid. For example, X borrowed 200,000 pesos with 10% annual interest from Y. Later, Y tells X that he no longer needs to pay the interest but must still return the 200,000 pesos. Only the interest is condoned, not the principal.
Condonation or omissions of debt is an act of generosity by a creditor that legally extinguishes a debt, provided it follows the rules of donations. It can be total or partial and must be either formally documented or clearly implied by creditors' actions.
So hi everyone, I Kurt Pa, and I assigned to report the section 4, the confusion or measure of rights under chapter 4, and the field of the obligation and contracts. One significant mode of extinguishing obligation is the confusion or measure of rights. This concept is covered under chapter 4, particularly in Article 1275 to Article 1277 of the Civil Code. This report aimed to provide a comprehensive and detailed explanation of the confusion or measure of rights, exploring its legal basis, conditions, and examples. So, Section 4, the confusion or measure of rights. Confusion, also known as merger, is a legal doctrine that results in the extinguishment of an obligation when the same person become both the creditor and the debtor of the same obligation. This principle prevents a person from owing or demanding payment from themselves, making it illogical to enforce an obligation. So the first article is the Article 1275, the extinguishment of the obligation by confusion. Article 1275 states the obligation is extinguished from the time the characters of the creditor and debtor are merged in the same person. This article established the fundamental principle of confusion. Once a person assumes both roles in an obligation, it ceases to exist. The rationale behind this rule is that an obligation requires two separate parties, one to demand and one to comply. If these two roles merge into one, there is no necessity for enforcement. For example, Anna borrows 5,000 pesos from Ben. Later, Ben writes a will stating that upon his death, all his assets and liabilities will be transferred to Anna. When Ben dies, Anna will inherit the obligation as both the creditor and the debtor. The loan is automatically extinguished because one cannot be both the creditor and the debtor of the same obligation. So, secondly, is the Article 1276. The confusion must be complete. Article 1276 states the confusion which takes place in the person of the principal, debtor, or creditor extinguishes the obligation, but if it occurs in the same person of the guarantors, it shall only extinguish the guarantee. This article differentiates between confusion in the principal obligation and confusion in the accessory obligation, such as guarantees. If confusion occurs in the person of the main debtor or creditor, the entire obligation is extinguished. However, if it only involves a guarantor, only the guarantee is nullified while the principal obligation remains intact. For example, David borrows 100,000 pesos from Eva and Frank acts as the guarantor. If Eva later inherits David's estate, the utang is extinguished. However, if Eva only becomes Frank's tagapagmana, the obligation will still remain, but the guarantee is voided. So, thirdly is the Article 1277, the exemptions to confusion. Article 1277 states the confusion does not extinguish a joint obligation except as regards the share corresponding to the creditor or debtor in whom the characters concur. Joint obligations involves multiple debtors or creditors, and confusion applies only to the person corresponding to the person in whom the characters of the creditor and debtor merge. The remaining shares of the other debtors or creditors remain enforceable. For example, Carlos, Diego, and Emilio owe 90,000 pesos to Felix in equal shares. In tagkuan sila tag 30,000 each. If Carlos will inherit Felix's rights as creditor, the confusion occurs only ni Carlos. And thirdly is the Article 1277, exemptions to confusion. Article 1277 states the confusion does not extinguish a joint obligation except as regards the share corresponding to the creditor or debtor in whom the two characters concur. The joint obligation involved multiple debtors or creditors, and confusion applies only to the person corresponding to the person in whom the characters of the creditor and debtor merge. The remaining shares of the other debtors or creditors will remain enforceable. For example, Carlos, Diego, and Emilio owe 19,000 pesos to Felix in equal shares, tag 30,000 sila each. If Carlos will inherit Felix's rights as a creditor, confusion occurs only for sa share ni Carlos, which is the 30,000. Diego and Emilio are still liable for their respective versions of the utang.
So good day everyone. This video covers Chapter 4, Section 4, Requisites of Confusion or Merger. First is the merger of the characters of the creditor and debtor must be the same person. This means the same person has to become both the one who owes the money debtor and the one who is owed the money creditor. Imagine Aling Maria owes Mang Berto 1,000 pesos. If Aling Maria becomes Mang Berto perhaps through inheritance or some legal process, then she is now both the one who owes and the one who is owed. This debt is extinguished. Second is the merger must take place in the person of either the principal creditor of the principal debtor. This clarifies who needs to merge. It has to be the main creditor or the main debtor. Let's say Aling Maria owes Mang Berto and Mang Berto owes Mang Cardo merge. That doesn't necessarily cancel Aling Maria's debt to Mang Berto. It only matters if Aling Maria and Mang Berto merge, or if Mang Berto and Aling Maria merge, the case is original parties to the debt. Last is the merger must be complete and definite. The merging of the roles must be absolute without any doubt. It can temporarily become Mang Berto. For example, if she manage his finance for a short time, that is not a complete and definite merger. The debt is still there. The merger has to be permanent, clear for the debt to be considered extinguished.
So next is I will be discussing the chapter 4 section 5 which talk about compensation. So it says here that compensation distinguished from confusion. So when we say compensation, it involves two persons who are creditors and debtors of each other. While confusion, it involves one person who becomes both the creditor and the debtor. So like for example in compensation, Alice owes Bob $100, but Bob also owes Alice $80. So instead of both making payments, they compensate by offsetting their debts. As a result, Alice now only owes Bob $20. While in confusion, example is that Bob takes a loan from the bank, but later Bob inherits the bank, which he becomes the owner of the bank. As a result, Bob can owe the money to himself, so the debt is extinguished due to confusion. So, in simple terms, compensation requires two people and two obligations, while confusion happens when one person is both the creditor and the debtor. So there are two kinds of compensation, the as to cause and as to effect. So in as to cause, there are four kinds of compensation: the legal, voluntary or conventional, judicial, and facultative. So when we say legal, it takes effect by operation of law from the moment all the requisites prescribed by law are present. So legal compensation automatically happens when all legal conditions are met. This means no one needs to take extra steps, the law itself makes the compensation happen. So simple example is, imagine Alex and Bob owe each other money. So Alex owes Bob $100 and Bob also owes Alex $100. Since they owe the same amount, the law automatically cancels out their debts. Neither Alex nor Bob has to pay anything. So that is legal compensation. So next is the voluntary or conventional compensation. So when we say voluntary or conventional compensation, it occurs when the parties agree to the mutual agreement to cancel out their credit without involving any strict legal requirements. So example of that is Bank A owes Bank B $500 and Bank B owes Bank A $500. So instead of both of them paying each other separately, they agreed to cancel out their debt. No more actually moves, but they both consider the debt settled. So another kind of compensation under the asta cause is the judicial compensation. So judicial compensation, it takes effect by judicial decree. So this means if two people have debts to each other but can settle them, a judge steps in and decides how to cancel out what they owe. So like for example, Maria owes John $1,000, but John also owes Maria $800. So Maria refuses to pay the full $1,000 and instead wants to offset John's $800 debt. So John disagrees, so Maria takes the case to court. So the judge rules that Maria only needs to pay the remaining $200 after deducting John's debt. So in this case, the court has to step in and declare that debts should be cancelled out. So this is the judicial compensation. The last one is the facultative compensation. So this compensation can be set up only by one of the parties. So this occurs when only one party has the right to demand compensation but not both, only one. So for example, Chris owes David $1,000, but David owes Chris $700. However, only Chris has the right to decide whether to offset the debt. If Chris wants, he can force David to only pay the $300 difference, but David cannot demand that Chris automatically deducts amount. So that is the facultative compensation. So the other kind of compensation is the as to effect, and under of it is there are two, which is the total and partial. So when we say total, the two debts are of the same amount. So like for example, if you both borrow $50 each, your debts are the same. You both owe an equal amount. Well, when we say partial, the two debts are not of the same amount. So like for example, if you borrow $80 and your friend borrows $50, the debts are not the same. One of you owes more than the other. So in simple terms, total means equal debts while partial means different debts. Under the article of 1279, in order that compensation may be proper, it is necessary that each one of the obligors be bound principally, and that he be at the same time a principal creditor of the other. So in simple terms, both parties must be debtor and creditor to each other. Then, both debts consist in a sum of money, or if the things due are consumable, they be of the same kind and also be the same quality of the latter has been stated. So, like for example, if both debts are money, it's fine. But if one is money and the other is a car, compensation can't happen unless the car is valued in money terms. So next is the two debts be due. So, if one debt is due today but the other is payable next year, you can't offset them until both are due. Then, they be liquidated and demandable. So, the amount must be clear and agreed upon. If one party disputes the amount, compensation isn't possible until resolved. Then, the last one is that over neither of them there be any retention or controversy commenced by third person and communicated in due time to the debtor. So it means that there must be no legal restriction. So if a court has put a hold on the debt, or like in cases of retention or legal disputes, compensation isn't allowed. So in order that compensation may be proper, it is necessary to follow the requisites mentioned in Article 1279. What is the difference between the debt and the claim? So when we say debt, this is an amount that has already been confirmed and is due. So it means someone officially owes money. While when we say claim, this is more like a demand for money that isn't yet fully recognized as a debt. It's a potential debt, but it still needs to be established. So in short, a debt is a finalized obligation, while a claim is just a request that might turn into a debt if proven. Under the article of 1280, notwithstanding the provision of the preceding article, the guarantor may set up compensation as regards what the creditor may owe the principal debtor. So this article essentially means that if a guarantor or the person who guarantees a debt has to pay the creditor or the person owed money on behalf of the principal debtor or the original borrower, the guarantor can offset the payment against any money the creditor already owes to the principal debtor. So basically, if the creditor owes the debtor money, the guarantor can use that to reduce what they have to pay. So, Article 1281 states that compensation may be total or partial. When the two debts are the same amount, there is a total compensation. So, as I have mentioned earlier, when we say total compensation, it happens when the debts are equal, meaning they cancel each other entirely. While when we say partial compensation, it occurs when the debts are not equal, so only the smaller debt is cancelled and the remaining balance must still be paid.
Article 1282 states that the parties may agree upon the compensation of debts which are not yet due. So, this article refers to an agreement between two parties to compensate or offset debts, even if those debts are not yet due for payment. So, it means that if balance ng ilang debt sa usag-usa, they can agree to compensate or cancel out the amounts owed instead of waiting until the debts are due. For example, si person A na ay utang nga 50 pesos kay person B. Unya, nag-agree sila nga ilang bayaran karong October 15. And then, si person B is nagka-emergency and nangutang of 50 pesos kang person A. So, bisag wa pa'y October 15, pwede na nila i-cancel out or compensate ang ilang utang sa usag-usa kay balance naman ang iba. The Article 1282 pertains to conventional or voluntary compensation. When we say conventional or voluntary compensation, it is when the parties agreed to the mutual extinguishment of their credits. Ang conventional compensation mo na ang regular payment or the basic payment when doing your job, while ang voluntary compensation mo na extra perks or ang bonuses you get that gives voluntarily. There are two requisites of conventional compensation. First is that each of the parties can dispose of the credit he seeks to compensate. This means that both people involved has the right to use the money or value that they owed in the deal. For example, if one person owes money and the other person owes money, they should be able to use the money they are owed. So the second requisite states that they agree to the mutual extinguishment of their credit. It means both parties agree that the amount they owe each other will be cancelled, or they agree to erase the debts against each other instead of paying in cash. Kaya naman sila utang sa usag-usa with same amount, so they can cancel it. So now let's move to the difference between legal compensation and conventional compensation. Legal compensation happens automatically when both people owe each other money or things and the law allows it to cancel out. For example, person A has a debt to person B a 50 pesos and the person B has a debt 50 pesos to person A. So pareha sila nga na utang sa usa nga 50 pesos. So by law, they can cancel it out without asking. While unconventional compensation happens when both people agree to cancel each other's debts. For example, si person A na utang ni person B na 50 pesos, si person B has the same na utang na 50 pesos ni person A. So, but this time, they agree to cancel each other's debts instead of paying money. So, ang kalayaan sa legal compensation and conventional compensation, ang legal compensation happens automatically by law, while ang conventional compensation contains agreement between parties. So now let's move on to Article 1283. 1283 states that if one of the parties to a suit over an obligation has a claim for damages against the other, the former may set it off by proving his right to set damages at the amount. So this article involved in a legal case about debts or obligation where they have a claim for damages against the other party and they can use that claim to reduce or cancel out the debts. For example, si person A nagpautang og 5,000 ni person B. Ang wa pa nabayaran ang utang ni person B. So, si person A naka-cause of damage ni person B. So, ang amount sa iyang na-cause na damage is 1,000. So, ang 1,000, instead of suing person A, nasa the agreement na 1,000 ibawas na lang adto sa utang ni person B. So, nanalay ba na 4,000 sa person B ni person A. Article 1284. So, Article 1284 stated when one or both debts are rescissible or voidable, they may be compensated against each other before they are judicially rescinded or avoided. So, the Article 1284 are correlated or connected to Article 1381 and 1390, which are rescissible contracts and voidable contracts. Article 1285 states that the debtor who has consented to the assignment of rights made by a creditor in favor of a third person cannot set up against the assignee that the compensation which would pertain to him against the assigner, unless the assigner was notified by the debtor at the time he gave his consent that he reserved his right to the compensation. So, ano yung namitabo ang assignment of rights or transfer of rights where when the assigner transfer the legal rights or claim to someone else or to the assignee. For example, you lend money to someone else, ang imong right na i-claim ang katong money, imong gipasa adto sa assignee because you are busy. So, ang assignee mo na ay right na dawatong kanang utang sa debtor. There are effects of the assignment of rights. First, if the debtor consented to the assignment of rights made by a creditor in favor of a third person, he cannot set up against the assignee the compensation which pertains to him against the assignee. Second, if the debtor consented to the assignment of rights made by a creditor in favor of a third party, he reserved his right to the compensation, then he can set up against the assignee the compensation which pertained to him against the assigner. Third, if the assignment is made without the knowledge of the debtor, he may set up the compensation of all credits prior to the same and also later ones until he had knowledge of the assignment. Article 1286 states that compensation takes place by operation of law, even though the debts may be payable of different places, but there shall be an indemnity for expenses of exchange or transportation to the place of payment. So, for example, kanang si person A na utang 100,000 pesos to person Y. Nagkadto si nag-offer to siya sa Philippines. Si person Y na napoy utang 100,000 pesos to person X nag-offer to siya in USA. So, whoever asked to offset or compensate their debts, ang mag-ask gani to compensate mo to siya ang gasto sa extra kay di ba kay lahi ang currency sa US dollar o sa Philippine peso. So, kinsay mo ask sa offset mo to siya mo bayad sa extra expenses to cancel their debts. So, here in Article 1287 states that compensation shall not be proper when one of the debts arises from depositing or from the obligations of a depository or of a payee income. In Article 1287 says that compensation can happen in the following cases. First, if one of the debts comes from a deposit or from the responsibilities of someone who is holding something in commoditum. Second, compensation also can be used for a claim for support that is given for free. So in this article, compensation cannot be used for debts related to safekeeping, loans for use, or free support like financial help. Article 1288. states that neither shall there be compensation if one of the debts consists in civil liability arising from a final offense. So it means you can't cancel out a debt if it's related to damages from a crime. Now let's move on to debts which cannot be compensated. First, debts arising from contract of depository. So it happens when the depositor gives something to the depositary to keep it safe, and the depositary has the responsible to protect it and return it when asked. Second, debts arising from a contract of commoditum. So in this, the commoditum is you can loan a thing but you must return it, like borrowing a book or a car for a while. Third is that claims for support due by gratitude status. So if you give support to others like their personal needs like food, shelter, clothes, it doesn't mean nga mabawasan ang imong debt sa ila because support is freely given without expecting returns. So it doesn't mean nga kitahayog na kay utang nila dyan mo support kasi ilang basic needs. It doesn't mean nga mabawasan na dito imong utang nila. Naagi hapon na, di hapon na mabawasan. Dahil ang support. So lastly is the one of the debts consists in civil liability arising from a final offense. So it means that if one of the debts is a civil liability resulting from a crime, compensation cannot be used. This is because the law requires that the person responsible for the crime must pay the full amount, and allowing compensation would not be fair or inappropriate. So, in Article 1289, if a person should have against him several debts which are susceptible or compensation, the rules on the application of payment shall apply to the order of the compensation. It means that if you have multiple debts that can be compensated, the rules for how payments are applied will decide which debt is cancelled first. For example, na kay 10,000, 5,000, or and 3,000. You can decide asa adito ang amount that imo i-compensate first. Article 1290. When all the requisites mentioned in the Article 1279 are present, compensation takes effect by operation of law and extinguishes both debts to the concurrent amount, even though the creditors and debtors are not aware of the compensation. So here in Article 1290 says that when all the conditions in Article 1279 are met, compensation happens automatically by law. This means both debts are cancelled out to the extent of the same amount, even if the people involved don't know about it. So person A owes person B 100 pesos dyan. Si person B owes person A 100 pesos. They can cancel their debts because they meet the conditions mentioned in Article 1279. So that's all for the Article 1282 to Article 1290.
Section 6. Novation. In the civil law setting, novatio is literally construed as to make new. So Article 1291, obligations may be modified by changing their object or principal conditions, substituting the person of the debtor, subrogating a third person in the rights of the creditor. So under Article 1231 of the New Civil Code, novation is enumerated as one of the ways by which obligations are extinguished. So the burden to prove the defense that an obligation has been extinguished by the novation falls on the debtor. So what is the consideration in a contract of novation? So the consideration need not be pecuniary or even beneficial to the person promising. So what is novation? Novation is the extinguishment of an obligation by the substitution or change of the obligation by a subsequent one which extinguishes or modifies the first. So in order that the novation can take place, there are four. First, there must be a previous valid obligation. Second, there must be an agreement of the parties concerned to a new contract. Third, there must be the extinguishment of the old contract, and fourth, there must be a validity of the new contract. So is there a form required in novation? So as a general rule, no form of words or writing is necessary to give effect to a novation. So novation is not presumed. Novation is never presumed, and the animus novante, whether totally or partially, must appear by express the agreement. So there are kinds of novation. First is as to subject. So the part of the as to subject, there are three. real or subjective, personal or subjective, and mixed. So the real or subjective is made either by changing the object or the principal conditions. The personal or subjective is by substituting the person of the debtor or subrogating a third person to the rights of the creditor. And the mix is by changing the object or the principal conditions and by substituting the person of the debtor or subrogating a third person of the rights of the creditor. So the second kind of novation is as to constitution. So as to constitution, there are parts also, express and implied. So express when the new obligation declares in unequivocal terms that the old obligation is extinguished. So the term expressly means that the contracting parties incontrovertibly disclose that their object in executing the new contract to extinguish the old one. And the implied is when the new obligation is incompatible with the old one on every point. So the third kinds of novation is as to extent or effect. So their parts also, first is total or extensive, and partial and modificatory. So total or extensive is when the old obligation is terminated by the creation of a new one that takes the place of the former. The partial or modificatory is merely modificatory when the old obligation subsists to the extent that it remains with the amendatory agreement. And the last kind of novation is as to origin. First is the part of the as to origin is legal and conventional. So the legal novation which takes place by operation law, and the conventional is novation which takes place as stipulation of the parties. So let's circle the kind of the novation. First is as to the subject. Second, as to constitution. Third, as to extent or effect. And fourth is as to origin. So that's it. Thank you.
So good morning everyone. This video covers the chapter 4 section 6, which is focusing on the test of incompatibility and the crucial concept of novation, both partial and total novation, along the kinds of personal novation. Test of incompatibility means whether the two obligations can stand together, each one with its own independent existence. If they cannot, they are incompatible and the later obligations novates the first. It means that if you have two agreements or obligations that conflict with each other so much that they can't both exist at the same time, the newer agreement replaces the older one. So the older agreement is essentially cancelled. Novation as mode of extinguishing obligation may be done in two ways. First is express declaration. The new obligation explicitly states that it replaces the old one, while implied, the new obligation is incompatible with the old one to such a degree that the old obligation is implicitly extinguished. Like for example, you have a new contract to buy a car for $10,000, then later you sign a new contract to buy the same car for $9,000. The $9,000 contract is incompatible with the $10,000 contract. So, the second contract, which is the $9,000, is replaces the first contract, which is the $10,000. So next is the total novation versus partial novation. The effect of novation may be partial or total. There is partial novation when there is only a modification or change in some principal conditions of the obligation. Then, it is a total novation when the obligation is completely extinguished. Right, for example, you owe your friend at $20. In total novation, you give your friend a total of $20 gift card instead of cash. The original debt is completely gone, replaced by the gift of card. Then in the partial novation, you pay your friend $10 now and promise to pay the other next week. Then the debt still exists, but the payment terms have changed. So in the article of 1292, states that in order that an obligation may be extinguished by another which substitute the same, it is imperative that it be so declared in unequivocal terms, or that the old and new obligations may on every point incompatible with each other. So this means that if the parties don't explicitly agree to replace the old contract, novation can only occur if the two obligations cannot coexist, making them mutually exclusive. So in essence, novation is never presumed and must be explicitly agreed upon or proven through incompatibility. So next, in Article 1293 says that novation, which consists in substituting a new debtor in the place of the original one, may be made even without the knowledge or against the will of the latter, but not without the consent of the creditor. So it explains how a debt can be transferred to new person. The old debtor can be replaced by a new one, even if they don't know or agree. However, the person the money is owed to the creditor must agree to this change. Once the new person pays, they get the same rights as the original debtor. Then, payment by the new debtor gives him the rights mentioned in Articles 1236 and 1237. Then let's move on in kinds of personal novation. There are two kinds of personal novation. First is substitution and the second is subrogation. So first is substitution. Substituting the person of the debtor or someone else takes your place as the debtor, the one who owes, or creditor, the one who is owned. Again, substituting the person of the debtor, someone else takes your place as a debtor, the one who owes, or creditor, the one who is owed. So example, you owe Bob $100. Then your friend agrees to pay Bob instead of you, and Bob agrees to this. So if Bob releases you from the debt, your friend's payment is valid substitution of the debtor. Then you no longer owe the money. And lastly, subrogation means subrogating a third person in the rights of creditor, or someone pays your debt for you and then they get to collect the money from you instead of the original person you owed. Only the person you owed and the person you who paid need to agree. So for example, you owe Bob $100, then your mom pays Bob. Now, your mom can demand the $100 from you.
There are two modes of substituting the person of the debtor. The first one is the expermission. The initiative for the change does not come from the debtor and may even be made without his knowledge, since the third person would substitute for the original debtor and assume the obligation, his consent and that of the creditor would be required. Substitution of the person of the debtor may be affected by the second kind of substitution, the delegation, meaning that the debtor offers and the creditor, or what we call delegatario, accepts a third person who consents to the substitution and assumes the obligation, thereby releasing the original debtor from the obligation. Here, the intervention and the concept of all parties thereto would perforce be necessary. Note that in either of these two modes of substitution, the consent of the creditor, such as such as can be seen, is an indispensable requirement. According to the Article 1296, when the principal obligation is extinguished in consequence of a novation, accessory obligations may subsist only insofar as they may benefit the third persons who did not give the consent. So we have to remember the general rule about the effects of novation of a principal obligation on accessory obligations. So when the principal obligation is extinguished in consequence of novation, the accessory obligations are also extinguished, except when the accessory obligations may subsist only insofar as they may benefit a third persons who did not give their consent. So according to Article 1297, if the new obligation is void, the original one shall subsist, unless the parties intended that the former relation should be extinguished in any event. The general rule of the effects of novation where the new obligation is void is if the obligation is void, the original one shall subsist. Take note that the first requisite of a valid novation is that there must be a previous valid obligation, except the parties intended that the formal relation should be extinguished in any event. According also to the Article 1298, the novation is void if the original obligation was void, except when annulment may be claimed only by the debtor or when ratification validates acts which are voidable. The general rule of the effect of novation when the old obligation is void is the novation is void if the original obligation was void. This is because void obligation is existent again. Take note that the first requisite of a valid novation is that there must be a previous valid obligation. We have an exception of the general rule of effects of novation where the old obligation is void. When annulment may be claimed only by the debtor or when ratification validates acts which are voidable. Voidable obligations are binding unless they are annulled by proper action in court. They are susceptible of ratification. Classification cleanses the contract from all its defects from the moment it was constituted. According to Article 1299, if the original obligation was subject to a suspensive or resolutory condition, the new obligation shall be under the same condition, unless it is otherwise stipulated. For example, X obliged himself to give Y a particular cell phone if Y passes the CPA board examination. Subsequently, X and Y agree that instead of giving a cell phone, X will give a specific laptop. Is the giving of the laptop subject to the same suspensive condition? Of course, yes. X will deliver the laptop only if Y passes the CPA board examination.
Subrogation. So what is subrogation? Subrogation, by the definition, is the transfer of all rights of the creditor to a third person who substitute him in all his rights. So there are two kinds of subrogation. First one is the conventional subrogation, and second one is the legal subrogation. The conventional subrogation is that which take place by agreement of parties. Legal subrogation, which take place without agreement but by operation of law because of a certain act. So, conventional subrogation and assignment of rights distinguish. The conventional subrogation is the transfer of all rights of the creditor to a third person who substitute him all in his rights, so which take place by agreement of parties. The debtor's consent is not necessary, so subrogation extinguish an obligation and give rise to new ones. The nullity of an old obligation may be cured by subrogation, such as that the new obligation were perfectly valid. So assignment of rights is the assignment of credit happens when the creditor, the assignor, transfer the right to receive payment to someone else, the assignee. So this transfer does not require the debtor's permission and can happen various reasons, like a sale or donation. And the assignee then has the same rights to collect the debt as the original creditor. So the debtor's consent is not required. Assignment refers to same right which passes from one person to another. So the nullity of an obligation is not remedied by the assignment of the creditor's right to another. So the court has established a clear difference between two concepts, assignment of credit and conventional subrogation. This distinction is important because it affects whether the debtor's consent is needed. So an assignment of credit, the debtor does not need to give consent for the assignment to be valid. So they just need to be notified about it. So the assignment takes effect once the debtor is involved or informed. So in contrast, conventional subrogation requires an agreement between the original creditor, the debtor, and the new creditor. So it involves a new contract that necessitates mutual agreement from all parties involved. So in more recent cases, the Supreme Court stated that the law does not require any formal notice bind to the debtor to assignee.
All that the law requires is knowledge of the assignment. So even if the debtor had not been notified but came to know of the assignment by whatever means, the debtor is bound by it. So Article 1301, conventional subrogation of a third person requires the consent of the original parties and of the third person. Well settled is the rule that novation by substitution of creditor requires an agreement among the three parties concerned: the original creditor, the debtor, and the new creditor. So it is a new contractual relation based on the mutual agreement among all the necessary parties. So hence there is no novation if no new contract was executed by parties. So Article 1302, it is presumed that there is a legal subrogation when the creditor pays another creditor who is preferred even without the debtor's knowledge. Second is when a third person not interested in the obligation pays the express or tacit approval of the debtor. Third one is when or even without the knowledge of the debtor, a person interested in the fulfillment of obligation pays without prejudice to the effects of confusion as latter shares. So what is legal subrogation? Legal subrogation is that which take place without agreement by operation of law. Because of certain acts, this is the subrogation refers to the Article 1302. So like for example, X owes Y 500,000 secured by real estate mortgage, and Z paid the amount of 500,000 with the consent of X. So in this case, Z is the subrogated in the rights of Y. So whoever pays for another may demand for the debtor what he has paid, except that if he paid without the knowledge or against the will of the debtor, he can recover only insofar as the payment has been beneficial to the debtor. So even without the knowledge of the debtor, a person interested in the fulfillment of the obligation pays without prejudice to the effects of confusion of as to the latter's share. So Article 1303, subrogation transfer to the person subrogated to the creditor with all the rights there is to appertaining. So either against the debtor or against the third person, be they guarantors or possessors mortgage, subject to stipulation in conventional subrogation. And Article 1304, a creditor to whom partial payment has been made may be exercise his rights for the remainder, and he shall be preferred to a person who has been subrogated, so in his place in virtue of the partial payment of the same credit.